Hello everyone, very warm welcome to StudyIQ IAS English. I'm your educator Praveen Mishra and let's start the burning topic of the day. So as you can see, a face of triumph that is coming from the Telangana Chief Minister, that is Mr. Revanth Reddy. So Mr. Reddy has now shown an affirmative action with regard to the reservation policy or the enhancement of the reservation policy inside the state of Telangana. And his government has finalized or technically implemented the Scheduled Caste Categorization Act from today, that is April 14, 2025. Technically, they are paying tribute to the great personality, okay, on his birth anniversary, that is Bhim Rao Ambedkar. Okay, so will it be providing enhancement to the reservation policy considering the upliftment and safeguard of the scheduled caste community inside the state of Telangana, or will it create some sort of ruckus or any sort of disturbances with regard to the reservation policy? So, well, to be very precise and to be very honest, it's not going to create any such type of ruckus or a problem, as it's categorization, and the categorization is basically based on following the protocols of the national reservation policy only, and it has nothing to deal with, or it has nothing actually sort of amended the reservation policy, right? So everything is good and fine, just categorization has been done to go ahead and targeting the actual needed beneficiaries, right? So what are the features? What is this actual SC Categorization Act or the Scheduled Caste Categorization Act? So according to the 2011 census, the Telangana state, it comprises exactly 59 communities that are belonging to or tagged as the Scheduled Caste community. Now, according to the SC Categorization Act, there will be three groups: Group 1, Group 2, and Group 3. So out of 59, Group 1 will be consisting of the 15 of the most disadvantaged communities inside SCs. Okay. So they comprise nearly 3.288 percentage of the population, and they will be granted 1% of the reservation, right? Group 2, it shall have, okay, includes 18 moderately benefited communities, okay, moderately benefited, okay, that is comprising nearly the 62.74 percentage of the population in the state, okay, and they shall be given with 9% of the population. And Group 3, the most underrated one or the most underdeveloped one, Group 3 consists of the 26 relatively better off communities, not underdeveloped, a better off communities, okay, making 33.963 percentage of the SC population, and they shall be entitled with the 5% of the reservation. So the category 1, that is the most deprived one or the most underdeveloped one, okay, that is with regard to 3.288% of the 3.288 percentage of the population, okay, that is 15 communities there. How much percentage? 1%. Okay. Group 2, once again we have got the 18 communities there, okay. How much percentage? 62.74 percentage, okay. And what will be the reservation allotment? 9% of the seats, okay. And apart from that, the last one, that will be bit better as compared to the Group 1 and Group 2, okay, comprising a population of 33.963%, and they shall be granted with 5% of the seats, okay, or the 5% of the reservation. So in total, we can grant 15%, the maximum cap, okay, 15% of the reservation to the scheduled castes inside a particular state, okay. And in that 15%, according to the SC Categorization Act, Group 1, 2, and 3, they will be given 1%, 9%, and 5% of the reserved seats respectively, right? So this is what the SC Categorization Act. Now, what is the genesis? How it came forward? So it came forward after the 1st of August 2024, when Supreme Court gave the clear-cut ruling that the scheduled castes as well as scheduled tribes sub-categorization is legally permitted. It is constitutionally allowed. Okay. So on 1st of August 2024, okay, hearing the petition from the Punjab and Haryana High Court's judgment, okay, Supreme Court overturned its previous judgment or the previous ruling in the E.V. Chinnaiah versus the state of Andhra Pradesh 2004 case, and stated that yes, the scheduled caste sub-categorization, okay, in fact, the scheduled castes as well as scheduled tribes sub-categorization by the states is legally permissible, constitutionally allowed. And hence, the Telangana government, immediately within a month, within a couple of months basically, that is in October 2024, established a committee, and the committee was named as Shamim Akhtar Committee or the Shamim Akhtar Commission. Okay, the moment Supreme Court gave the judgment, within couple of months, Telangana government took the very cognizant and affirmative action and established a committee to inquire into the sub-classification, okay, sub-categorization of the scheduled caste community. Okay, and hence they established what? The Shamim Akhtar Committee. Okay, so the committee received nearly 8,600 of the representations, and they went ahead with the holistic approach. Holistic approach as in measuring each and every parameter, okay, that is measuring each and every point of the social life, from higher education to financial aid to political participation, okay, distribution, etc., etc., literacy levels, okay, everything. Simply speaking, a holistic approach was followed by the Shamim Akhtar Committee, okay, or the Shamim Akhtar Commission, in order to identify the classification, okay, identify the groups to be classified, right? So they submitted their report, and the moment they submitted the report, Telangana Assembly formulated the Scheduled Caste Categorization Act. Okay, so what is the name of the commission, guys? Make it clearly. Okay, make it very clear. Shamim Akhtar Commission, established when? October 2024, following the judgment by the Supreme Court. Okay, so what is the more when we go ahead in the more of the history? So in 2004, okay, a case happened, and the name of the case is here, that is E.V. Chinnaiah versus the state of Andhra Pradesh case, in which Supreme Court clearly mentioned, I must repeat, clearly mentioned that the scheduled caste sub-categorization, the community's sub-categorization by the states, is not constitutionally permitted. So, if the states are going ahead with the sub-categorization of any scheduled castes or the tribes inside their states, it is illegal, it is unconstitutional, shall be declared null and void. This is what Supreme Court's judgment has been in the year 2004. What is the name of the case? E.V. Chinnaiah versus the state of Andhra Pradesh. Okay, but this judgment was later on overturned by the Supreme Court itself, and freshly Supreme Court has stated just last year that yes, sub-classification or sub-categorization is legally permitted. Okay, so the Supreme Court of India, in a review judgment of the Punjab and Haryana High Court, delivered a landmark verdict allowing states the authority to subclassify reserve category groups such as SCs and STs for the purpose of reservation, for the better purpose of serving the reservation, basically. Okay. So what's the next thing we need to discuss? Subclassification permitted, but yes, what one thing Supreme Court has stated, that states, while you are going ahead with the subclassification, make one thing clear, that the margin of 15% shall not be, violated. You should not cross the margin of 15% of the reservation given to the scheduled caste community. Okay, so you classify them into 1, 2, 3 or whatsoever groups, doesn't matter, but make it clear, make it sure, okay, make sure that the final capping is not exceeding the margin of 15%. Okay, so this is what Supreme Court has stated. Okay, and yes, the very next thing, in the very same judgment, Supreme Court has also stated that 100% of the seats should not be granted to one community only, one subcategory only. Okay, you have got 4, 3, 2 whatsoever subcategories in the scheduled caste communities, not a big deal, but yes, make it sure that 100% of the seats, they are not granted to just one particular subcategory. Okay, equal proportionate distribution should be there. If not equal, then yes, proportionate distribution should be there according to the research and analysis. But yes, make it clear that 100% of the seats is not given to just one subcategory, because then what will be the other categories, those who are left will be given. Okay, as finally 15% is the total capping, right? And yes, this particular subcategorization is not, hierarchy or the generational. Okay, the court stated that reservation has to be limited only to the first generation. In case the first generation has marginally developed itself, okay, above the margin, and hence the second generation will not be entitled for the same categorized reservation. Reservation will be there, categorized reservation should not be there. Okay, so this is what the Supreme Court has stated. Now, what is the case? Which case was the actual case, and what was the next case where the judgment was challenged, and what is the final case? Okay, so the issue of subclassification of the SCs, okay, and its referral to a 7-judge bench was initiated by a 5-judge bench in the case of State of Punjab versus Davinder Singh 2020. Basically, this time Supreme Court was hearing the petition from two distinct cases. Okay, one was the referral and another one was the petition. Referral was from the 2004 EV Chinnaiah versus State of Andhra Pradesh case, and second one was the State of Punjab versus Davinder Singh. Okay, so reconsideration of the EV Chinnaiah case. The 5-judge bench found it necessary to reconsider the EV Chinnaiah judgment, and what they did, the EV Chinnaiah ruling stated that the subclassification within SCs and STs, it is not permissible. As SCs, they do form a homogeneous group, and hence there will be no subclassification. So this was the judgment which was to be reconsidered by the Honorable Court. Okay, and came another thing into the picture as well, that is Punjab Scheduled Caste and Backward Classes Reservation in Services Act of 2006. Okay, so the Punjab government took a leverage, okay, against the EV Chinnaiah judgment and initiated a particular statute. What it is named as Punjab Scheduled Castes and Backward Classes Reservation in Services Act 2006. Okay, so the specific legal challenge in this case involved the validity of Section 4, Para 5 of the Punjab Scheduled Caste and Backward Classes Act of 2006. So it was challenged inside the Punjab High Court, Punjab and Haryana High Court, that is based in Chandigarh. Okay, so a division bench of the High Court in 2010 struck down this provision relying on the EV Chinnaiah judgment. Okay, so Supreme Court said, no, dear Punjab government, it's not possible, as according to the Supreme Court's ruling of 2004 of the EV Chinnaiah versus State of Andhra, we cannot provide subclassification. It's totally against the Constitution. Okay, so the High Court ruled that in the presidential order under Article 341 Clause 1, formed one homogeneous group, okay, and could not be subdivided further. So this is what Article 341 was mentioned by the High Court. That is, they are all homogeneous, okay, belonging to one set only, and they cannot be subclassified. But this was later on challenged, okay, and the Supreme Court finally gave the verdict that EV Chinnaiah judgment is to be overturned, is to be overruled, okay, and now the states should be given the proper authority or the proper flexibility, simply speaking, to subcategorize the scheduled castes or even the scheduled tribes inside their respective states. Okay, so the two cases that you need to hear, okay, that is the EV Chinnaiah once again, and apart from that, the Davinder Singh case, that is the State of Punjab versus Davinder Singh 2020, in which the Punjab's legislation of 2006 was challenged. The judgment came finally last year in 2024, okay, and following which the Telangana government took the cognizant action, okay, led by Revant Reddy, okay, and they established a committee. Name of the committee or the commission, that is Shamim Akhtar Commission, and they identified all the parameters and then they provided their report, and now the 59 scheduled castes, okay, inside the state of Telangana, they are categorized in three: category 1, 2, and 3. Category 1, that shall be given 1%, category 2, that shall be given 9%, and category 3 shall be given 5% of the reservations respectively. Okay, guys, so that's it with regard to the state of Telangana news. Okay, and please, if you are from Telangana, do share it with your friends and family, okay, and let everyone know that what your government has done, okay, specifically for the sake of providing boost to the social welfare and the secure welfare as well for the specific community, that is scheduled caste. Okay, everyone, so that's it from my side today. This is me, Praveen Mishra, signing off for the day here. See you soon in the next video. Bye bye, take care, good day, study well. Jai Hind, Jai Bharat.